Good evening, everyone. I'm Nan Aaron, President of Alliance for Justice, and thank you all so much for joining this evening's program. We are all in for a big treat. Criminal defense attorneys and advocates like Abbe Smith, Paul Butler, and so many of you who are joining us this evening play a critical role in making our justice system more humane, fair, and accessible to everyone. We're thrilled that after years of Trump and his allies stacking our courts with ultra-conservative judges, we are now providing the new administration with names of exemplary, wonderful candidates, including many criminal defense lawyers and public defenders. Our Building the Bench program is ready with a pool of potential nominees who will reverse the damage caused by so many of the Trump judges. Tonight's discussion builds on the numerous events we've had this year so far through our Holding the Court program. This program has reached out to lawyers, activists, progressives, supporters, and we're so glad you're all with us tonight. The topic tonight couldn't be timelier. Incarcerated people have faced brutal conditions, jeopardizing their lives with insufficient COVID procedures and protections. Millions of Americans this summer took to the streets to demand fundamental changes to law enforcement, to stop police violence against Black communities and communities of color. But everyday fierce advocates like Abbe and Paul, like the impacted communities on the front lines of our criminal justice system, like so many of you are in the courts, in the streets, in the halls of Congress, and at every turn tirelessly fighting for progress. Abbe Smith's book, Guilty People, is about those members of the bar who work to uphold the rule of law, about lawyers on the front lines representing guilty people, defendants who sometimes commit heinous acts. Her book provides a critically important perspective as we as a country talk about criminal justice. She makes sure we never forget that the humanity of these people being judged is never forgotten, and why our constitutional protections are so important. Abbe is a professor at Georgetown Law School and director of the Criminal Defense and Prisoner Advocacy Clinic. She has fought to give meaning to the words etched in our highest court, equal justice for all. Paul Butler also teaches at Georgetown Law School in criminal law. Before Georgetown, he was a federal prosecutor, bringing many public corruption cases. He is one of the most frequently consulted scholars in the field, commenting on the national airwaves and in the pages of leading media outlets. You've probably seen Paul on MSNBC, and you should be sure to read his recent Washington Post op-ed on the need to radically reshape our law enforcement and criminal justice system. With that, thank you all for joining us. And Paul, I am turning the program over to you. Thank you.
Thank you, Nan, and thank you to Abbe Smith for writing this important and eloquent book. Like Abbe, the book is very wise and very funny and very compassionate. I learned so much and I laughed a lot too. So I'm going to get us started on first hearing Abbe read a bit, and then we'll have a great discussion, including questions from the audience. So Abbe, if you please.
Thanks so much. Thank you to Nan. Thank you, Paul, for joining us. Nan and Paul are two of my very favorite people on earth. As I've often felt compelled to explain in the course of writing a book called Guilty People, this is not a history of the Jews. It is instead a book about people who run afoul of the law and end up in the criminal legal system. Guilty people are not monolithic. While it is true that some people commit serious crime, others commit minor, even trivial crime. Some are guilty of something, but not what they're charged with. Others may have committed the crime charged, but with significant mitigating or extenuating circumstances. Some have committed the crime, but they've never done anything like it before. They lost control in a trying situation. Others commit crime out of immaturity, imprudence, or impulse. Some are gifted criminals, others clumsy and feckless. The truth is, I like guilty people. I prefer people who are flawed and complicated and do bad things to those who are irreproachable and uncomplicated and do the right thing. Flawed people are more interesting. Those we think of as the worst often turn out to be not so different from the rest of us. As Clarence Darrow once said, everybody is a potential murderer. I've never killed anyone, but I frequently get satisfaction reading the obituary notices. Or, as Katharine Hepburn argues as a defense lawyer in the movie Adam's Rib, assault lies dormant in all of us. It requires only circumstance to set it in violent motion. Fittingly, Hepburn objects to the characterization of a wronged wife accused of trying to kill her husband's mistress as a, quote, criminal. This is a strange thing to call a citizen, wife, and mother, she says. Unfortunately, this more nuanced view of criminal conduct is difficult for many to grasp. That is, until a friend or family member is arrested. Then, miraculously, criminals become multidimensional people. When people ask how I feel about clients lying to me, I often say if I had a court-appointed lawyer with hundreds of other clients, I'd probably claim to be innocent too. How else to motivate the lawyer? Of course, some clients lie because they are ashamed of what they've done and of having been arrested. They revisit the shame with their lawyer no matter how non-judgmental we try to be. They want us to think better of them. It reminds me of a story from my friend Kathy's childhood. When she learned to write, she took a bright red crayon and wrote her name, Kathy, 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 all over the family's white piano. When confronted by her father, Kathy denied she had done it. Still, many clients are painfully honest. Take, for example, a client I'll call Renee Cooper. Ms. Cooper was African-American in her mid-50s, obese, toothless, and always fretting about something. How she would get to court, how she would get to the mental health clinic, the long lines at drug testing, various family problems. Ms. Cooper had been in and out of trouble much of her life. She had a long record consisting mostly of drug possession and prostitution, but she had also done time for selling drugs. She was doing well on probation when she caught a new prostitution charge. The facts of the case were memorable and not in dispute. Ms. Cooper had offered to perform oral sex on an undercover police officer in exchange for fried chicken. Ms. Cooper was only slightly humiliated to have been arrested under these circumstances. As far as she was concerned, she was hungry, and a blowjob in exchange for dinner was not a bad trade. But the arrest was a problem. It was a violation of her parole and meant she had to go to court on the new case. We tried hard to get her to complete mental health diversion, a therapeutic treatment-oriented alternative to criminal prosecution, so that Ms. Cooper might avoid a new conviction and parole violation. But she missed meetings, tested positive for drugs, or waterloaded before testing, and otherwise failed to comply with the requirements of diversion. So the mental health judge put her back on the regular criminal calendar. This was not a triable case, and Ms. Cooper knew it. She figured she would plead guilty and throw herself on the mercy of the court. Her goal was to stay out of jail. By some miracle, her parole officer took pity on her and did not charge her with a violation for the new crime. So the only thing we had to worry about was whether the judge before whom Ms. Cooper was scheduled to appear would send her to jail for doing something as desperate as offering a blowjob for fried chicken, assuming she was going to continue to test dirty or otherwise fall short on pretrial release. I got a kick out of Ms. Cooper. She always greeted me with a big bear hug. She called me Ms. Abbe. She was funny and charming. She said she had heard of me, that I was known as a great lawyer. I doubted this. The case dragged on for a while, Ms. Cooper trying her best to comply with pretrial release conditions. She was ultimately placed on probation, notwithstanding her less than perfect performance. The judge said the important thing was she had no new arrests. I think I wasn't the only one charmed by Ms. Cooper. Alleged rapists are among the most reviled criminal defendants. When a woman lawyer represents an alleged rapist, she inevitably faces the offshoot of the constant query made of criminal defenders. How can you represent those people? This is alternately expressed as, how can you be a woman and represent a rapist? Or more broadly, how can you be a feminist and a criminal defense lawyer? Of course, women are not the only ones who find representing alleged rapists difficult. Many men do too. I once represented a man accused of child sexual abuse who had admitted his guilt to me. When there was no reasonable alternative, no reduced sentence in exchange for a guilty plea, we went to trial. I cross-examined the child complainant in accordance with the defense theory. The child's mother's boyfriend, not my client, had sexually assaulted her. There was some support for this theory in a police report. The girl told an officer that when she was awakened by an intruder climbing into her bed, she thought it was her mom's boyfriend. The child was around 11. Because my client had told me he did it, I knew she was telling the truth. Moreover, the child's explicit account of what happened matched my client's, even though he had been high on cocaine and ecstasy at the time. The tone of my cross-examination was soft and reassuring. I like kids and know how to talk to them. She agreed that she had mentioned her mom's boyfriend to the police officer who questioned her after the incident and said that he sometimes came into her room. We talked about how attached her mom was to the boyfriend and how hard it was to say anything bad about him because of that attachment. She agreed that life was much better before the boyfriend came to live with her and her mom. She trusted me. I seemed to understand her and wasn't out to get her. I didn't make her talk about the details of what had happened like the prosecutor did. As a result, the cross-examination went smoothly, and I made the points I needed to make. During recess, she came to find me in the hallway. She told me she was going to camp that summer and wondered if I had ever been. She said she liked to play softball and was good at it, especially fielding. She asked me if I had any kids. I gently discouraged this contact. I didn't want to hurt her feelings, but I also didn't want her to think I was her friend. Still, she kept coming back to me. I felt like a terrible person. This child had been raped by my client, and now she trusted and liked her rapist's lawyer. She didn't understand the argument I had constructed through my cross-examination, that I was calling her a liar. I would make this abundantly clear in my closing while offering a sympathetic reason for her false accusation. Here's the other problem. I liked her too. Would have been happy to talk about camp, softball, or whatever else she wanted to talk about. I wanted to show up the next day with my spare infielder's mitt. I played third base in a local women's softball league. I wanted to tell her how sorry I was about what had happened to her, what my client had done, and what I was doing now. I wanted to tell her she was going to be okay, that she would get through this and have a good life, that she was strong and resilient. I would have done all this if only I wasn't the lawyer on the other side. But under these particular circumstances, to say or do any of it would have been an even greater betrayal than what I had done at trial. Defense lawyers do not get to apologize, no matter how much we may want to. To do so would be vain and narcissistic. Victims of serious crime get to hate us. It's the least we can do for them. My client was acquitted. I still think about that little girl. I wonder what became of her. I hope she got past what happened to her. I hope she has no memory of me. Many people believe there is an identifiable defender personality. My favorite rendering of the defender personality is by Mary Halloran, the former executive director of the Colorado Criminal Defense Bar. She calls criminal defense lawyers, quote, a breed unto themselves, and describes them as profane, argumentative, insecure, eccentric, and ill at ease with people who are not themselves criminal defense lawyers. She adds, they can't complete a sentence that doesn't include the F word, and the more frequently and creatively it's used, the more effectively they feel they've communicated. Halloran allows that defenders have a few positive qualities. Oddly, she notes, they make loving parents. We are all flawed. At our best, we recognize our failings and struggle to overcome at least some of them. I often say that if I had been born as disadvantaged as most of my clients and remained trapped in poverty, I would probably be a shoplifter. It's not that I believe stealing is okay. It's that I'm a shopper. And if I lacked the means, I would probably still be a shopper. I'm reminded of Rosalie Cunningham, about whom I wrote in the first chapter of this book. She was a misdemeanor version of my Jewish grandmother. When Rosalie's grandchildren needed winter coats, she went to a local Washington, D.C. department store and boosted them. When my siblings and I needed new coats, my grandmother took us to Marshall Fields in Chicago and bought them. Of course, shoplifting is hardly the sole province of the poor. My partner Sally's grandma Annie was a compulsive thief, perhaps a kleptomaniac. All manner of things could be found in her massive pocketbook, including steak. Apparently, her behavior was well known. Her son had an arrangement with a small grocery store in her apartment building that they bill him rather than call the police. No one was safe from Grandma Annie's sticky fingers. Sally's mother would buy cartons of cigarettes, Montclair Menthol Gold 100s. When Grandma Annie stopped by, several packs would go missing. Afterward, when Sally's mom paid her mother a call, Grandma Annie would proudly present her with a pack of her own cigarettes, announcing, "Betty, I have your brand." I don't feel guilty about my inner shoplifter, but I would be guilty. There is more than enough guilt to go around, but not enough shared responsibility. Too often, we fail to see ourselves in people who commit crime, preferring instead to see them as the other, a criminal, or a bad person who needs to be caged and cast off. Ferdinand von Schirach, a German criminal defense lawyer and writer, puts it this way: we chase after things, but they're faster than we are, and in the end, we never catch up. I tell the stories of people I've defended. They were murderers, drug dealers, bank robbers, and prostitutes. They all had their stories, and they weren't so different from us. All our lives, we dance on a thin layer of ice. It's very cold underneath, and death is quick. The ice won't bear the weight of some people, and they fall through. That's the moment that interests me. If we're lucky, it never happens to us, and we keep dancing. If we're lucky. Thanks.
Thank you, Abbe. Everybody knows that you are a brilliant defense attorney. So people now get to see and hear what a gifted writer you are. And drum roll, what a gifted cartoonist you are. So yes, folks, the book actually includes Abbe's own drawings. Who knew? So President-elect Biden is in the news today because he warned civil rights organizations to stop saying defund the police. And President Obama also said last week that defund the police is bad messaging that gets in the way of criminal justice reform. And I'm thinking about messaging and wondering, if you're interested in reform, why write about guilty people? So your book talks about racism and sexism in the criminal legal process, about mass incarceration, about police violence. If you want to create change, wouldn't it be better to focus on those issues rather than guilty people?
First of all, let me share with you the motivation for writing the book. Previous book I wrote, called Case of a Lifetime, was the story, it was kind of a lawyer's memoir about my efforts to obtain the release of a woman I always strongly believed was factually innocent. And I first came to represent her as a law student. She ended up serving more than 28 years in prison for a crime I believe she didn't commit. And although in the book, I include the importance of representing the guilty along with the innocent, some of my favorite proteges, former students and fellows, were kind of disappointed that, you know, of all people, I would write a book about an innocent person. And I explained to them that book sort of had to be written. It was written initially as part of my advocacy on the client's behalf, and it was such a formative case for me, but I understood their complaint because I like to call the program I run at Georgetown a guilty project, not an innocence project. And, you know, I say that somewhat provocatively, but I mean to underscore that that is the work of criminal defense lawyers. It's the heart of the work of criminal defense lawyers. And we do it because there's no difference between guilty people and innocent people and the rest of us when it comes to basic humanity. And I think we've lost sight of that in this country. It wasn't always so. In the 19th century, when Tocqueville came to write about the American criminal justice system, he found us refreshingly lenient, that the way in which we took serious individual lives caught up in the system was sort of remarkable to him. And we've come full circle now, you know, as the leaders in putting people in cages. So I think there are important stories to be told. And I think if we tell the stories and about the guilty and talk about messaging, I think my side hasn't done a very good job of capturing the public imagination when it comes to people locked up and banished. Their imaginations get captured by stories about innocent people being exonerated, but not so much about the people we lock away for way, way, way too long, and for a vast array of criminal offenses, many of which just don't require that level of punishment. As to, you know, the reform question, you know, I guess I'm really, in my heart of hearts, a criminal defense lawyer. I'm much better at representing individuals and complaining about the government not meeting its burden of proof than I am conceptualizing a different system. Though I will say this, you know, the structural problems are real. I don't think reform is sufficient. We never ever talked about reforming slavery. We talked about abolishing it. Our prison system is a travesty. The idea that in the 21st century, the best we can do is put people in steel cages, I just think is wrong and contrary to everything we know about, you know, what it takes for people to change. I understand the politics of defunding the police are difficult. You know, it's not a business I'm in. Maybe there is better nomenclature we could have used that we don't put people off. But there too, we need to fundamentally reconceptualize.
Great. So I want to hear more from you about abolition in a bit, but I want to press you on the innocence versus guilty distinction, which you don't seem to think is a big deal. So you wrote a book about an innocent person. I wrote a book chapter about an innocent person, me. And the time that I caught a case and got prosecuted for a crime that I didn't commit. That story is in my first book, Let's Get Free. And you have a short version of that same story in Guilty People. And then, Abbe, you say about my story that my innocence wasn't really the point of the story. But for me, it was one of the points. It mattered to me that I was innocent. And so the question for you is there an important distinction between innocent and guilty people in criminal court? And specifically, wouldn't you work harder for someone who you thought was actually innocent? And wouldn't you feel worse if an innocent client was convicted as opposed to a guilty client being convicted?
Well, that's a wonderful question. And it deserves a thoughtful reply. So let me try. First of all, I'm sorry if I sort of used your story in a way that undercut your experience of it. Of course, it was important that you were innocent, but I use the story in Guilty People to underscore how terribly people are treated, how mean people were to you, how dehumanizing the experience was, and that everybody locked up with you in the jail when you were falsely accused by a wacky woman, everybody in that jail along with you, you're all presumed innocent. Nobody's been adjudicated anything, and people should not be treated that way. Shouldn't be rounded up like cattle, shouldn't be shackled one to the other and thrown into a large cell. I care about human dignity. And, one of the mantras of criminal defense lawyers is that good people sometimes do bad things. And the initial passage I read, in which I quote Clarence Darrow and others, is kind of meant to make that point that any of us could end up screwing up and doing something bad. It doesn't mean that the rest of us is no longer existent. It doesn't mean the rest of us bites the dust. I do a little experiment. Well, I guess it's more of an exercise with the investigative interns that work in the criminal and juvenile defense clinics at Georgetown, in which I pass out index cards. And I say to them, I want you to write down on this card the worst, most shameful thing you've ever done. And I reassure them, nobody's going to look at the card. You can shred it or tear it up. And in fact, after you write it down, you can turn it over so nobody sees it. But I want you to give some thought and write down the worst, most shameful thing you've ever done. And, for some of us, it's going to be hard to pick and choose. For others, you're going to have to dig deep and come up with something, but everybody does. And then I have them kind of sit with it. And I say, now, imagine that what you wrote on that card is all anybody thinks about you, not your sparkling personality, not your loyalty and generosity to family and friends, not your various interests and talents, but just that shameful thing you wrote on that card. And now imagine that the very same system that's most punitive towards you, that's angriest and most judgmental about what you wrote on that card, has sent you a lawyer to represent you. Because this is our client's experience. They no longer feel that they're fully who they are, that they're fully human. And I think that happened to you. And perhaps it was even worse because you didn't belong there, because you shouldn't have been arrested in the first place. And I understand, deeply from representing my client, Patsy Kelly Jarrett, that she felt the same way, that there's a terrible, terrible indignity in being falsely accused. And I'll tell you, there's no greater burden for a criminal defense lawyer than representing somebody you believe is factually innocent. You feel this enormous burden that you stand between just unspeakable injustice and your client, and the power of the government looms large and nobody will listen to you, when you announce the truth of your client's innocence. But even though it may be more emotionally grueling on some level, I feel the same way when I'm representing somebody who may well be factually guilty, but is facing the same horror of a conviction and criminal punishment in this country, in our system. And sometimes it's the harshness of punishment that kind of ratchets up my zeal and emotion on behalf of the client. Sometimes it's just getting to know the client, and understanding that, human frailty of, in a bad moment or for a host of reasons, they did something bad. But I often feel the same way. I guess the more serious the crime sometimes, the more emotional the connection and the greater the need for zealous advocacy, but that's even not always true. I share in the book a number of misdemeanor cases in which I felt the same way. Quite often, a misdemeanor charge is the very first time a person faces the criminal system, and it's just as big for that person. It doesn't matter that it's a misdemeanor. I mean, incidentally, I should say that the book is divided into 5 chapters. Chapter 1 is petty criminals, chapter 2 is ordinary felons, chapter 3 is rapists, chapter 4 is murderers, and chapter 5 is called Guilty Clients, Guilty Lawyers. And it kind of digs around some of the motivations of criminal defense lawyers.
So let's talk about the rapist and the murderers. How can you represent people like that? So it's a question that defense attorneys get asked all the time. And I've heard you answer that question. So I've also heard you say, though, that you could represent any guilty person except those who hold one occupation. And what's that occupation, Professor Smith, and why couldn't you represent those guilty people?
I can't believe you've retained that little exception, Paul. That's amazing. So the only category of clients that I would not represent are currently employed police officers accused of brutality. And the reason I've carved out that exception, and I should say I've never turned down a court appointment. I never turned down a case when I was a public defender and was assigned a case, not based on the nature of the offense, not based on a client's record, certainly not based on guilt or innocence. The reason I carve out that exception has to do with my constituency. I am a poverty lawyer. I represent poor people accused or convicted of crime. And these are the folks, my clients, who bear the brunt of police brutality. And so I'm just picking a side here. Moreover, there are always more than enough lawyers who run to represent accused police officers. Sometimes they're union lawyers, and sometimes they're just lawyers in the community. Often those are fairly high publicity cases. And I recognize that it puts me in a strange position. In other words, I'd rather represent somebody who I thought committed a brutal rape than a police officer who shoves somebody around. Yeah, that's just the way I kind of see my life's work.
And let's talk about representing a brutal rapist, which is one of the stories that you read. How old was the survivor in that case when she was raped?
11.
And she took the stand, and you tried to make the 11-year-old girl look like she was lying about being raped, but you knew that she wasn't lying. And then because of your zealous defense, a rapist went free. So two questions. One is, how are you okay with that as a feminist? And the other question is, do you ever feel guilty about what your client might do since he wasn't punished for his rape?
I'll take the second one first. Not particularly guilty about an acquittal on behalf of somebody who was alleged of any crime. I see that as giving people second chances. Do I hope they don't go out and reoffend? Yes, of course I do. I do as a human being. I also do as their lawyer. I hope in that case of the guy with the 11-year-old, he was actually willing to plead guilty. I persuaded him to go to trial because there was no payoff. He wasn't going to do any worse at trial than taking a plea for a mandatory minimum 5-year sentence. So that was my legal advice. It put an additional burden on me once I advised him to go to trial. But that's what lawyers do. We advise people about trial and plea. He was a good guy. He was terribly ashamed about what he had done. He wanted to plead guilty in part to spare the child from having to take the stand. And so he's somebody who I believe was capable of seeking help, the kind of help he wouldn't have gotten in prison. He committed the crime under the influence of some pretty potent drugs. That's not to suggest that everybody who takes those drugs engage in that particular conduct. And I'm not so grandiose to think that I somehow, prevailed upon him to, look deep within and change himself. But I hope he did. I think it was a watershed moment for him. The first question, how can I, as a feminist, I see criminal defense work as consonant with feminism. It may not always feel consistent, but in so many ways, it fits my brand of feminism. The feminism I embrace is deeply aware of hierarchy. It's deeply aware of the cycle of violence. I mean, the locus of sexual violence in our society is in some of our most cherished institutions, the family, schools, church, the military. I mean, it's a societal problem as well as an individual problem, and there is a feminist analysis of that. You know, I think you have to feel bad as a human being. I think I'd be a bad lawyer if I wasn't aware of the emotional pull of a child on the witness stand. I think you have to recognize that, and not to sound cold, but use it as a lawyer. If you know that somebody is going to be particularly powerful on the stand and present a kind of vulnerability, you have to engage in lawyering that respects that and maybe even exploits that if need be. But you know, that's what criminal defense lawyers do. I think it's fine to go back, and I think it's really important to go back to your office after a case that challenges you in those ways. And there are two categories of cases that I think are especially challenging for this generation, for progressive people and feminists in particular, and that would be representing rapists and racists. And, you know, in other words, representing people accused of hate crimes of, you know, a wide variety. I think it's one of the things that public defenders like best about the work we do is that you get to go back to the office and vent, you know, with your colleagues, and, you know, get hugs and high fives when you win a case. And if you would ask me, how'd you feel after winning that case? I would have said fantastic, like $1 million, thrilled, like I'd pulled a rabbit out of a hat. You know, I got somebody acquitted who was factually guilty of a serious offense. I gave him a second chance. You know, maybe it's the adversarial system, maybe there's a competitive instinct in me, but I did not shed a tear over that verdict. But, you know, I write about it hopefully in a way that conveys that some cases just break your heart. They break your heart all the way around.
So what would you say to that little girl if she's listening right now?
I'd say what I wrote in the book. I hope you're okay. I hope you got through it. You know, I hope you had support. I hope you somehow had the resources or the opportunity to talk about it and work your way through. You're more than that. You know, I hope you're resilient enough to have made your way through.
And she says, I might be okay, but no thanks to you.
I'd say fair enough.
Do you identify as an abolitionist? Or do you think that there are some guilty people who deserve punishment?
Well, I really admire abolitionist theory, but I'm also not a Pollyanna about crime. You know, you don't have to love crime to be a criminal defense lawyer, which, you know, by the way, is not for everyone. Not everybody has what Barbara Babcock used to call the heart set, mindset, soul set of a criminal defense lawyer. But some people need to be removed from society because they're dangerous. I don't think anybody's born to be dangerous. I don't believe in the notion of a bad seed, but I think bad things happen to people and they become damaged, and some damaged people are very dangerous. You know, I don't think we should confine them under the conditions that we currently confine people in this country. I think it's barbaric. But I do think, of course, that some people are dangerous. But by prison abolition, the theory imagines a different approach, a different system of both punishment and hopefully some form of reparation in there. I think the best idea of abolition incorporates a kind of restorative justice approach to resolving criminal problems that include much more meaningfully victims of crime as well. And yes, I believe in reconceptualizing the system and employing those kinds of theories.
And part of restorative justice is recognizing that people are flawed and that they make mistakes, and that punishment sometimes isn't the thing that's going to help the survivor. And along those lines, I'm wondering, do you have post-trial or post-plea conversations with your clients, with your guilty clients, where you do a little finger wagging and say, just because I got you off doesn't mean.
You know, probably yes, the older I get. When I was younger, I was probably appropriately more humble, and maybe less grandiose, because, you know, the truth is really, how effective can I be? You know, if I say go and sin no more, will those words from me somehow make the kind of impact that would cause somebody who's likely to reoffend not offend? I kind of doubt it. But sure, I have those conversations. I try to have those conversations if invited, if I've established enough trust and rapport with a client so that I know they're really interested in talking through ways they can think differently about the situation that got them into criminal trouble in the first place. I'm acutely aware of the fact that I've been appointed by the court, that my clients don't choose me, that they don't look through the yellow pages or talk to their country club friends and you know, get a name of a lawyer. I'm kind of foisted upon them by the same system that, you know, is punishing them. So I think it's important to be invited. It's important for me to feel that it's a conversation that would be welcome and that might make a difference. And I have no problem, you know, saying that. I've no problem pointing out, man, you were lucky.
Okay.
I have to say, I recently watched the mini-series, The Undoing, and I loved the defense lawyer in that series. And I love, except for she made a terrible mistake in the defense case, but I love how she talked to her client in the end. And I don't want this to be a spoiler, but it's worth watching that series. And I kind of liked how she was with the client.
Yeah, it was really interesting. I watched it as well, and actually the mistake that the defense attorney made in that case. No spoiler alert here, but kind of resonates with your story about cross-examining the little girl in your case.
Right.
So,
she should have left well enough alone.
yeah, and actually, so that brings me to like the golden rule of trial advocacy. You have to know when to shut up. So I'm going to ask one more question, and then I'm going to shut up. So again, you touch on a lot of themes that people have written about, including racism in the criminal legal process and sexism in the criminal legal process. I wonder if you could reflect on the national reckoning on race this summer, and whether it makes you optimistic about about both the future of reform and also about your role. You and I have talked a lot about defense attorneys and whether their work is part of systemic change, or on the other hand, whether you're just another cog in the system. And to that extent, the fact that you're now here talking and writing about, oh yeah, my clients are mainly guilty, that also is kind of what you're supposed to do, that defense attorneys in some ways help justify what's going on right now.
Gee, I hope not. I was really heartened by the activism of this past spring and summer. I do not think that criminal defense lawyers are cogs. I kind of hate that. I've come to loathe that word, cog. My students sometimes raise the same question. I guess I'll have to write something that has the word cog in the title just to get it off my chest. But no, I really don't believe so. And I'm talking now about good, devoted, zealous, reasonably well-funded criminal defense lawyers. No, you know, we are not a cog, and that we should not be. I like to think of criminal defense lawyers, especially indigent criminal defense lawyers, who are in this work for the right reasons, because we believe in the dignity and humanity of our clients, because we know the system is systemically on every level against them. And so those folks, you know, of which I consider myself part, I like to think that we are allies, even better than allies. That allies has come to feel like a kind of weak word. accomplices on the inside to folks, what folks are doing on the outside. Somebody has to represent the individual. I believe deeply that it's important to represent an individual. That's why so many people who are locked up write letters to me and to you, Paul, and to anybody else who teaches criminal law or who writes an op-ed about some criminal related issue. You get dozens of letters then from people who don't have the means to hire a lawyer, who are dying for a lawyer, who are locked away somewhere. I think it's really important that lawyers stand beside people in trouble and in need. And that's really the definition of a criminal defendant. And I'm hoping that what's happening out there is a movement and not a moment. You know, I worry, and I'm old enough to remember that there were other such moments when I thought, okay, it's going to happen now. There's going to be a groundswell. And then people kind of go about their business. This feels different to me. The number of demonstrations I participated in felt different. The way our law students and young people are talking feels different. The way some politicians are talking feels different. Some of the folks that Biden and Harris are consulting with are different. They're deeply progressive. They're people who are going to talk to them about the school to prison pipeline, who will talk about meaningful police reform and not just changes around the edges. And so, I don't know, I'd kind of like to be hopeful. You know, the past 4 years have been so depressing. Let's be hopeful about something.
So we got some great questions from the audience. One is, how did you learn to effectively cross-examine someone like the 11-year-old child with kindness and delicacy? And the person says that she's asking as a brand new lawyer.
Well, I was really lucky. I had some fantastic training. During law school in the summers, I worked at a public defender office in New Haven, Connecticut, and they were really good lawyers who were models. In law school, I was lucky enough to be in a year-long clinic 2 out of the 3 years of law school. And one was a prison law clinic where I got to meet with, work for, hang with lifers in particular, in both a men's prison and a women's prison in New York. And then I was lucky enough to land a job after law school, and my clinical teachers were wonderful and certainly gave me some initial training. But I would say that my ability to be a trial lawyer, that I owe it to my 8 some odd years at the Defender Association of Philadelphia. They had a really good training program. They were really good lawyers. And I think you learn on your feet in the final analysis. Hopefully people are observing you and can give you feedback. But I think you take the skills that you've learned, and you can't do it outside of a courtroom. You have to really immerse yourself in the work. What I say to my students is go and try a ton of cases. You have to get immersed, and you have to prepare really hard, obsessively, and then reflect really hard afterwards, because we all know it's not just experience that makes you good at something. There's plenty of people we all know who have been doing things for years and years, and they're still not any good at it. Why is that? I think it's because they haven't reflected hard enough. They haven't learned from experience. And I believe in not making the same mistakes, but making new mistakes. And so that's what you have to do, because you also, if you're a new criminal trial lawyer, I believe in a really high standard, especially when you're representing poor people. But you're gonna make mistakes. You can't be perfect. Trial work is just too fast. It's too rapid. You're gonna end up missing stuff. One of my favorite lines from a friend of mine, a career public defender in Rochester, New York. She said, the real reason criminal defense lawyers like to win at trial? And I said, no, why? She said, so that nobody will ever see the transcript with all the idiotic things we did. And I just love that. I think it's brilliant.
So effective cross-examination, I'm interested in that in the context of guilty people, because what that means if you're cross-examining a government witness is that you're making someone look like a liar when you know that she's actually not a liar. And in terms of how you learn that skill, I mean, is the instruction that explicit?
I think so. You know, there are certain catchphrases that then should show up in your closing argument, because there's kind of a relationship, like a sibling relationship between cross-examination and closing arguments, so that the points you make in closing ought to live in that cross-examination. And you cross-examine for motive and bias. You cross-examine for inconsistent statements because they suggest a person can't keep their story straight. You cross-examine for implausibility. You cross-examine for unreliability, meaning maybe the person didn't have such a great opportunity to observe or ability to observe, perceive, recall, and recount information. There are certain, you know, of these overarching concepts that you want to employ, and then you kind of dig down on them. And
So-
yes, they are learnable. One of my favorite people was the longtime training director for the Colorado Public Defender Office used to say, give me anybody. I can train people to cross-examine. I can train anybody to cross-examine. I could train a chimpanzee to cross-examine, she used to say. And I used to say, I'm not sure that's a great analogy.
And also the point you made about leaving it inside the courtroom. I think every trial lawyer has been accused of not doing that. Do you keep track? This is the next question. Do you keep track of the behavior of folks who you've successfully kept out of the penal system, who you thought were guilty? Or are any of your clients repeat offenders of serious crimes? And the questioner says, I'm not trying to guilt you, but does that have an effect on you?
It's okay. It's the first day of Hanukkah. I think we ought to all be feeling a little guilt and having a little guilt. Anyhow, I couldn't resist that. No, I do not keep track. Look, one of the benefits of being a criminal trial lawyer in a big city, and I've practiced in Boston, New York, Philadelphia, DC, is it's kind of anonymous. You know, it's a large city. I don't tend to run into either clients or witnesses, you know, in grocery stores or at the movies or what have you. That's probably kind of lucky. Most clients who I've represented at trial don't keep in touch with me. It's not a happy memory for them. It wasn't a fun thing that they want to kind of be in touch with me about. If they've made it through the experience, I don't blame them. You know, they want to let go and move on. So they don't keep track of me and I don't keep track of them. And I guess I'm lucky that I have never had that experience where somebody I've represented who I strongly believed to be factually guilty got out and do it again. I have friends who've experienced that, and I think it's an incredibly difficult thing. But grandiosity is a problem for lawyers generally, and maybe especially for trial lawyers, and I think you have to ward against that. I'm not the only person in the courtroom. It wasn't just me. I'm not so powerful as to be responsible for what a human being does, you know, before, during, or after a trial. And there's a prosecutor there. You know, if I've succeeded in obtaining an acquittal, you know, for somebody who's factually guilty, maybe the prosecutor didn't do a very good job. I don't think it's just on me. You know, there are jurors, there's a judge. So that's, maybe I'm just comforting myself a little by kind of suggesting that there are others who might bear some responsibility, but I think you take comfort where you can find it in this business.
Yeah, so maybe time for one more question. And the person says, what do you see as the role for defense lawyers or defense lawyer personality types in a restorative justice-based system? And to that, I'd just like to add, I'm intrigued by the defense lawyer personality type. And I'm wondering if that's a thing. Is there a defense attorney personality type? And, you know, some people would say, well, one flaw in that personality might be some kind of savior complex. And as somebody who thinks a lot about race and crime, I'd say a white savior complex. So is there a defense attorney personality type? And again, what's the role of defense attorneys in a restorative justice practice?
All right, I want to push back on that savior complex thing. I really hate it. I've written against it. And in the final chapter of my book, I kind of dig around the idea that criminal defense lawyers are heroes and martyrs. I don't think it's a recipe for a career in the work. I think it's terribly grandiose and also problematic, as most criminal defense lawyers are white and probably middle class. And a disproportionate number of our clients, especially in indigent criminal defense, are Black and brown. I think it's inappropriate. I don't regard myself as anybody's savior. I have power, that's true, as a lawyer, but I believe I have the power to help and the power to serve. And that's how I regard it. And I feel really lucky. It feels like a privilege to represent my clients. And I think there's always going to be a need for criminal defense lawyers to stand between our client and the enormous power of the state, even if we get some vestige of restorative justice. There's just always going to be a need. So I don't think that's going to go away. I want to leave you with one story, if I can. I know we have a couple minutes left, if that's okay, because it kind of answers some of the questions about, people who go on to do bad things and about how dangerous it is for criminal defense lawyers to try to get people off. In a phrase, one of the things that I've learned over the years, and Paul, I know you know too, because you've spent some time with lifers, and that's people change. I participated in a resentencing hearing for a man who served 33 years in prison for an armed rape. It was a bad crime that he committed 33 years ago in connection with a kind of drug turf rivalry payback. The crime was more complex than simply the charge would suggest, but he is a completely transformed person. He does such good work within the prison and has helped so many people there, and is a gentle soul. He's read so much feminist literature. He's basically a feminist. He's a beautiful writer. He's the kind of person whose respect people want to earn. And during the sentencing history, all the prosecutor could talk about was the crime he committed, the nature of the crime and how terrible it was, and that the victim is probably serving a life sentence. Why shouldn't he stay in prison for the rest of his life? And a bunch of people testified. I testified on his behalf because I've known him through a legal research and writing course that we teach in his institution. A forensic psychologist testified about a risk assessment and what a low risk of reoffending he is. But the best witness who testified was somebody who had served time with him and had recently re-entered society and was working with an organization of other men to help re-entering citizens. And during the cross-examination by the prosecutor, where she kept hounding him about the crime, he stopped and he turned to the judge and he said, "Your Honor, the crime doesn't change. The person changes." And it was a really eloquent moment. I've never heard it said better. So I'd like to leave folks with that thought, because that is very much at the core of what good, dedicated criminal defense lawyers do for a living. We believe in that.
Wow, so I said the mark of a good trial advocate is to know when to shut up. Nothing to say after that, but thank you, Abbe Smith, for this brilliant book. I think people got a sense of how challenging it is, no matter what you think you know or think this is going to disrupt that, make you think about it again. Eloquent and mad funny. Thank you to the Alliance for Justice. Thank you especially to Abbe Smith for your amazing work.
Thank you, Paul. Love ya.
Love you too. Good night, everybody.